You're listening to the Bail in the Midwest podcast.
Hello and welcome to the Bail in the Midwest podcast, where we explore a variety of topics related to bail, pretrial release in the criminal justice system in the Midwest. My name is Shane Rolf. I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 35 years. In our very first episode, we talked about so-called bail reform and a number of the problems with ultra-lenient pretrial release policies. Today, we're going to look at some of the primary arguments in support of bail reform and see if those arguments can withstand scrutiny, and if not, the best way to counter these arguments. My guest today is Jeff Clayton, the Executive Director of the American Bail Coalition. Jeff has been on the front lines of this fight for several years. Welcome to the podcast, Jeff.
Thanks for having me. Appreciate it.
Jeff, I personally know that you're one of, if not the preeminent voice when it comes to making arguments in support of bail. If you could give us your basic CV and background in bail so everybody else knows, along as I do, how great you are and how knowledgeable you are.
Well, I appreciate that. That might be a little overstated. I've been the Executive Director of the American Bail Coalition for the last 7 years, so it's been a long ride doing that. I've traveled to 35 states and done some federal stuff, all on bail. Over the last 7 years, including, media, going to state capitals, doing that, negotiating bills. So we did a referendum effort in California. So it's been an interesting and challenging 7 years. Prior to that, was a state house lobbyist, had my own firm for several cycles. Prior to that, lobbied for several government agencies at the state capitol in Denver, including the state courts and probation department for about 5 years. And then I also had the Department of Labor for a year. During the unemployment crisis. Prior to that, practicing lawyer, so represented primarily unionized police officers and federal civil rights and employment and other cases. And then prior to that, I was a presidential management fellow and worked at the United States Department of Transportation. So long and varied career, but I've spent most of it, at least the last 7 years, focusing on bail.
So you are an actual lawyer. So if we stumble into legal questions, you do know what you're talking about, as opposed to us bail bondsman types who don't always know those things.
Yeah, well, that's being a lawyer is good and bad, but maybe on this show it'll be helpful. So. Yeah.
Okay, so today we're going to review some of the major arguments in support of bail reform. And to get an idea about these arguments, I simply did a YouTube search on bail reform, and after weeding through all the news about exploding crime rates and their association with bail reform, I came across a video called "The Problem with the U.S. Bail System." And you've probably seen that before. It's presented as a TED Talk by Camilo Ramirez, who, as it turns out, after I looked him up, is not really an educator in the sense that we think of TED Talks being educational programs, but is instead the communications director for the Bail Project, which is, a charitable, I guess is one way to call it, a charitable bail fund. And this video, he makes a bunch of claims about why bail is bad. They're not necessarily, I'm going to take these probably not in order, but in the order that they strike me. And the first one of these ideas is that the presumption of innocence. The video specifically says that the presumption of innocence means that, quote, someone accused of a crime should not be imprisoned unless they've been convicted of a crime, unquote. Now, my personal opinion is that this argument resonates the most with the public. When you look at other things, the John Olivers and the Jim Jeffries and these other comedian approaches to looking at this issue, they always come back to this one. And I think most people have a Hollywood/Facebook understanding of most legal concepts and probably a traffic ticket level of experience with the criminal justice system. So this argument of the presumption of innocence means we can't hold anybody in custody seems to ring true to your average non-legal person. But this, I guess, a question for you: does this argument actually carry any weight legally?
Well, it does, but it's a confusing concept. That's a bridge too far for the presumption of innocence, and I'll explain why it is. When I first started practicing law, we had a saying that just because he's not guilty doesn't mean he's innocent. And so we often take that to a point where we assume that we presume that somebody did nothing. No, the presumption of innocence is a presumption that must be overcome by proof beyond a reasonable doubt. That's what it's there for. It's a presumption at trial that the prosecutor has to overcome. Now, it does protect certain rights in the pretrial space. And what does it protect? It protects you from punishment. That's what the presumption extends to in the pretrial context. In other words, we can't punish you for a crime that you haven't committed yet. The idea that the presumption of innocence prevents altogether pretrial detention is completely inconsistent with 700 years of English law. That's why we have bail. It's an exception to somebody being held in prison or in jail prior to trial. That's why we have bail. Bail balances that. Now, what does the U.S. Supreme Court say about the presumption of innocence in the bail context, in the late 70s, and I forget the decision name, it's not coming to me this morning, is that it doesn't extend to the pretrial context where somebody hasn't even gone to trial yet. And so, yes, we want to protect the presumption of innocence. Yes, we want to make sure that people aren't punished prior to trial. But no, it doesn't serve to excuse you of prior crimes that you've committed. And that's what judges are looking at, right? They're looking at the prior criminal record of the defendant and the prior failures to appear in court in almost all states. They look at that. And so the presumption of innocence certainly doesn't furnish grounds to extinguish prior criminal convictions for consideration, for example. And that's fairly black letter law as well. So you're right, the presumption of innocence, it sounds good in a general context that, yes, you shouldn't have to be subject to bail, but we could extend it to its logical extreme. Why should we arrest people then? That we would just not arrest people at all. We would just have to convict them first. And certainly, that's a bridge too far, I think, for the presumption. But you're right. I think the public misperceives what it is, its significance. It's important. We want to respect it, but at the same time, it doesn't serve to make everybody innocent in a pure sense that the criminal justice system can't even do anything to them at that point.
So then legally, and correct me if I'm wrong, since you're the lawyer here, and I'll probably refer back to that multiple times, but the actual legal standard for pretrial detention is not guilt beyond a reasonable doubt, but in fact is just simply probable cause, correct?
That's right. And also, the constitutional right to bail in sufficient surety states, of which Kansas is one, and the right to excessive bail. Those come into play too, right? You can't set a bail that's excessive. So we know that, but you're right. To get to the baseline level, it's just proof, probable cause standard.
So the presumption of innocence argument then sort of segues into the argument that defendants who are unable to post bond are unable to do so solely due to a lack of money. And usually the argument is that 60 to 70% of people in local jails are only there because they cannot afford to post bail. And I think they do the math on taking everyone who's not sentenced and claiming that the only reason they're in custody in the local jail is because they can't post bond. How accurate would you say this statement is? Because this is a statement we hear all the time.
It's generally false. I mean, we've, obviously, if we put a millionaire into every suspect's situation, then we could argue that they could post it. But that would change the bail setting process entirely. And that's why Paul Manafort had a $10 million bond, right? The judges are looking at assets to flee and they're setting bonds, and they should be higher if people who are wealthy are doing it. So why are people in jail? Studies that we've seen suggest that people who are in jail are twice as dangerous as those who get out. In other words, judges are looking at their prior criminal history record and their prior failures to appear in court. And so one study in New York found that the average defendant that didn't post bond had 10 prior strikes, combination of felony arrests and failures to appear in court. Those who got out had half of each. And so what's happening here is your prior record and your prior behavior, which we would want regarding your appearance in court, is taken into consideration by judges. Those who have less failures to appear are more likely to get out on a PR bond or a bond that they're able to post. And so that's generally why people are there, is because they have a record a mile long and they don't show up in court, and the judges do not trust them on a personal recognizance bond. That's why. Also, you've been accused of committing a crime in this sense. So this is not a pure debtor's prison as it's portrayed. And I could write these op-eds. I've seen the same op-ed for the last 7 years, and it goes something like this. On any given day, X amount of people are there, and they have been convicted of nothing. Well, not really. Not really. They've been convicted of a lot of stuff, just not the present charge. There's probable cause to support the present charge. And so they're there for those reasons. They're there for those reasons. And they're there as opposed to their counterparts who get out on bail because their record is this big, and their record over here who's getting out is this big. And the courts are able to Over here say, well, we'll allow them to, to be on pretrial conditions, and we'll allow them to post bail. Interestingly, when I first started in this business, a legislator told me, I used to do bail hearings in the 80s, and we had one of those stop matrix printers. And when we printed out the criminal history and the failure to appear record, we stuck it out and let it fall. And if it didn't hit the ground, then the guy got bail. And if it did, he didn't get bail. And that was, of course, in Washington, D.C. But that illustrates that's what's going on here. It's recidivism. And if you don't appreciate recidivism in the system, you really don't know what's going on. And that's what judges are looking at. These people have been there numerous times. They're not first-time offenders. They're not low-level drug offenders. And they may have been charged with a low-level crime today, but it's crime number 12 or crime number 7 or crime number 15, or in New York, heck, crime number 135. We had that case. That's what judges are looking at.
Well, and I believe that in the city of Los Angeles, didn't they do a study that indicated that only like 10 to 13% of the defendants who are held on a pretrial basis could actually even be released if they bonded at all, because they had detainers and holds from either immigration or other jurisdictions or other problems that they were facing, as opposed to just the case that there are.
Oh, yeah. You can't just take the pretrial population and suggest that they're all there because they can't afford it. Because, of course, there's other holds. They're on probation and parole. They have multiple pending cases. They've had bond revoked on this case. There's a lot of reasons why people don't get out. They're pending extradition to another state. See that a lot. So, generally they're not first-time low-level offenders. And the study that you cited out of Los Angeles, it's been a while since I've read that one, but generally what it found was that there were almost nobody in on misdemeanor charges on bonds that they couldn't post. It was a very limited amount. And in that case, it was, of course, the guy who had, 5 prior felonies who just, was shoplifting this time.
Okay, I'm going to revert back to the video again, because it comes up with a quote that I think kind of resonates, and I've heard this other places as well. It said, in order for cash bail to work as intended, the bail has to be affordable for the accused. And my understanding of this argument is, this is sort of just the beginning argument, is that if the court has decided to release the defendant on a bail at all, in any amount, then any amount the court sets that's beyond what the defendant has in his pockets is de facto preventative detention. And I personally faced this argument during the hearings before the Kansas Pretrial Justice Task Force, where they're like, well, we've already decided to let this person go, so then it's just a question of determining the amount. So where are we on this topic? A couple other questions to follow up on this, but where are we on this topic of affordability of bail? And is there a constitutional right to affordable bail?
Well, no, and as the U.S. Court of Appeals for the Fifth Circuit said, no such right is in view. I mean, I think that is settled, that you don't get a right to a bail that you can post. That's fairly black letter law at this point, despite the fact that the other side wants to continue to push this argument that everybody has to post bail. That's not what it's designed to do. And a key thing that in that statement was, if we're going to let them out. Well, that's what bail determines, if they're going to get out. It's not if the judge is going to let them out. That is up to the defendant. The judge's job is to set a bail that's sufficient sureties and inexcessive, right? A bail that's reasonably calculated to guarantee the appearance of the public safety and no higher. That's Stack versus Boyle. That's black letter. That's what it's designed to do. And so the idea that, oh, we're just going to let them out and then we decide what the bail is. No, that's the how much you got on you bail, I call it, right? And that's not what the system was ever designed to do. These people on the other side would have a much better argument if they just focused on the law, which is this bail is excessive for this defendant. And there's cases that have outraged society over the history of bail, where the judge in first-degree murder case in New York, for example, set a bail for a homeless guy at several $1,000s, and the community went nuts. But he said, listen, that is a bail that's not excessive for this guy. If he's able to post it and secures his appearance, I don't think he's going to go anywhere. He doesn't have any means to do anything. He has no assets. He has no resources, et cetera, et cetera, et cetera. So that's the measure of this litigation by, egged on by Eric Holder, starting with Varden versus City of Clanton, went on for 5 years. And we were part of that. That's O'Donnell versus Harris County. That's, Walker versus Calhoun, Georgia, which went up to the 11th Circuit, that also said there's no right to an affordable bail. So that's what the other side wants. They say it's de facto preventative detention. We don't think so, because we don't think preventative detention is a better process either. And if they say, if somebody's going to get out, well, that begs the question, why should they then? If we can get into the business of just denying bail, why should we have bail at all? And I think that is where the other side is shaky. When I first started, it was all about we want to get rid of bail and replace it with preventative detention. Then it was we want to get rid of bail and replace it with nothing, which everybody has discovered is not going to work. And now we're trying to walk it back to, well, we can do preventative detention. And New Jersey just proves that we can't restrain ourselves. We start at 24%. Now we're up to 47% a half decade later. We can't do it. We can't restrain ourselves. And that's why bail creates this right balance between, presumption of innocence and sufficient sureties and the right to bail.
Well, the counter argument that I came up with on that, or at least as that I tried to take off that, is that the court's release decision was conditional. It wasn't an absolute, you're just going to get released. We just have to determine the amount. It was a conditional release, and it was conditioned upon the defendant being able to provide some sort of sufficient assurance that he's going to come back to court to answer those charges against him.
Yeah, bail is security, right? And your bail is conditioned on meeting the security. And a personal surety system also means that the third party that's signing the bond, or if it's the defendant signing his own bond, but the third party personal surety is agreeing to the terms of the bond, the standard conditions, and that they'll be liable if they don't return the defendant. And that's what the personal surety system is. The bail is merely the security to guarantee the release. And of course, it's a condition, precedent to the release. You've got to post that before you get out. Right? Unlike a non-monetary condition, which we can't say, well, we're going to hold you in jail until we put the non-monetary condition in you. No, that's not a condition of, release. It's a condition of release, not a condition precedent to release. So absolutely.
And I guess when you do have someone who is truly indigent, and in my experience, those people are more of a flight risk than people who are not. I mean, the person who's a heroin addict living under a bridge, they're probably not going to come back to court, but they also are probably truly indigent. How are courts supposed to have a meaningful pretrial release for someone in that condition, someone who's truly indigent, who has no support, who has nothing to secure their appearance? I mean, are we supposed to just let them go, or are there other options for the courts to make determinations on?
Well, that's the $1 million question. And and as you said, those are the people that are there. And as one sheriff in Michigan, we had a panel as part of the Michigan Task Force said, hey, listen, we are the de facto mental health facility in Michigan. Now, that's wrong. That's not how it should be, but that's how it is. And he's right. For co-occurring disorders, mental health, substance use, that's what the jails unfortunately are right now. And whether it's a low-level crime this time or a high-level crime this time, those are the people that get ensnared. Bail is a test of your ties to the community. And once you've burned your bridges to the community, guess what? There are no personal sureties that want to put up for you. And research backs up the fact that misdemeanor cases are higher risk in terms of failing to appear and committing a new crime because the consequences are lower. We all know when you're facing 10 years in the joint, you're going to try to get yourself together before the next hearing and try not to commit a new crime before sentencing because, all of a sudden the maximum seemed like a good idea, right? And so statistics back up that misdemeanors are higher risk in terms of failing to appear and committing a new crime for that reason generally.
Well, anyone that sits through a traffic docket and, that they actually call the cases. I mean, a lot of traffic courts have stopped calling the cases. They have you check in with the clerk first so they don't have to call off the 50% of people who don't even show up and just send that message to everybody else who actually showed up that, hey, there's no real consequences for you not showing up.
Exactly. You have a text line where you can text in that you're not coming so we can just get you off the docket. Like in Harris County where, 78% of misdemeanor defendants don't show up in court.
So let's talk about increased crime. The TED Talk that I referred to, and I'll refer back to that again, quotes that since 2000, the annual number of people convicted of crimes has stayed steady, but the number of people in jail each year has shot up. Now, in my mind, this seems like an argument for a meaningful pretrial bond amount, and the current attempt to reverse this trend has resulted in exploding crime rates. Basically, as the population goes up, if crime stays steady, it means crime per capita is going down. And it's probably going down because there's more robust response to people that are committing the crimes. And so while these bail reformers use a, don't believe your lying eyes argument and really try and place the blame for increased crime on anything but their bail policies, what is the actual truth and what role does bail play in reducing crime?
Well, they can't have it both ways. When crime was going down and the jail population going down, it was all caused solely by bail, which we know it wasn't, at least according to the Brennan Institute in New Jersey. But then, of course, when crime's going up, they have no part of it. So which way is it would be my first question, to them. using convictions as a basis for increasing or decreasing crime really isn't a good one. You generally, FBI crime reports and crime reports by victims is the best way to gauge the crime level, because not everybody gets convicted. We know that. And I think for every conviction that a defendant, I forget what the statistic is on this, but for every conviction a defendant has engaged in that behavior any number of times before they get convicted. And so that's why the crime reports, I think, are important. Now, does changing bail policies increase crime? We've seen peer-reviewed academic studies that suggest it does. Intuition, and I think what we've learned from the Department of Justice suggests that 50% of crimes are caused by 3 to 5% of defendants. And who are those? Those are the ones that commit it over and over again. And so, yes, when we get into a bail situation where you have a 10-time defendant and we're pushing judges like in New York to letting those getting out on a PR bond, they get the message. And so it does have an impact, and particularly in violent and repeat situations, as the peer-reviewed study from the University of Utah found 45% increase in violent crimes as a result of bail reforms in Chicago. So there is definitely, evidence suggesting that. I think the bail reform in New York, the Mayor's Office of Criminal Justice data showed that people who went on the program as opposed to having to post bail had a new crime rate that was double those that posted bail. And so while, I don't think you can't argue that bail reform solely, and we would never do this, is driving the crime wave, because that would be irresponsible. We know it's other factors. We know it's diminishing the importance of the police, blah, blah, blah. There's a multitude of factors. We're not prosecuting crimes. We're reducing crimes. There's a lot of criminal justice reform that's happened over the last decade that probably has led to this, bail reform merely being one piece. But I think, the one thing that I've told people, and I think, is important to realize, is that if you look at studies that came out during the Obama Justice Department, they were trying to argue against length of sentence. But one of the research that they came up with that I think makes sense is deterring crime is really based on two things: certainty of getting caught and swiftness of punishment. And if you look at all the reforms through that lens over the last decade, what have we done? We've made it less likely that you're going to get caught. We made it less likely that you're going to get swiftly punished. And we've reduced sentences, sending the message on top of all that it's not going to be that bad. So we can't arrest our way out of this problem. And I've said that to a Republican legislator, and they said, oh, no, I think we can. We can jail our way out of this problem, but the reality is we can't. We have to have a policy of deterrence where people get the message. And that goes for bail reform all the way up to policing, to respect for the police, et cetera, et cetera, et cetera. All this reform needs to go through that lens. And I think if we do that, we'll have some success. But it's clear, and research has shown, that these bail reform policies have had an impact on increasing pretrial crime.
Well, one of the arguments that I've made on this topic is that, the bail process itself, basically being arrested and being forced to call your mother or father or friends or family members or whoever it is that you have to call to try and post the bond, that's your first opportunity at a meaningful intervention. Those people that are going to come help you post the bond, they're the people that want your life to get on a better track for the most part. And that's, you being arrested and having to call those people, then they can come and go, okay, this is what we're going to do. We're going to get you into rehab. We're going to get you to get a job. You're going to follow my rules. You're going to do these, steps A through C, to get you back on track. If the government just says, okay, hey, you got arrested and 10 minutes later, you're back out again, there's no intervention at all. There's no outside people that care about you that are taking any steps to get you back on track.
That's exactly right. And the old cliche is the process is the product. And that's how we've, deterred people in DUIs for any number of years. It's going to cost you $10,000. It's going to be painful. You're going to have to post bail. You're going to have to go to classes. You're going to have to jump through a million hoops as part of the process. And bail needs to be part of that process. And when we have a menu that says, if you're over here, you're out for free, that's bad. And that's why judges should base it on circumstances. That's what we advocate for, circumstances. Look at this defendant and make a decision so that the defendant knows, hey, I got to stare down the nose of a judge and make my argument that I'm not a risk. I don't want any piece of that. And so the more that it's automatic and the more that they don't look at the individualized characteristics of the defendant, the worse it is as well.
I think one of the articles, or actually it was a talk that I listened to, somebody was giving a talk on progressive prosecutors, and they were describing that was essentially lowering the transactional cost of committing crimes. Bail being one factor of that, but obviously the jail and the attorney and everything else. But as a progressive prosecutor, either didn't enforce, didn't require bail, didn't do several things, you were lowering the transactional cost of that crime. And if you lower the transactional cost of something, generally you get more of those things. I mean, it's just basic economic price point evaluation of things. If you lower the price, you're going to sell more product. If you make it less difficult to commit a crime, more people are going to commit crimes.
That's right. And I mean, amazing how times have changed. I talked to an officer who policed in the 70s and who said, Jeff, part of getting arrested in the 70s was you got roughed up on the way down. But a lot of times the DAs would just drop the charges because that was enough. Now, you know, things have certainly changed, but you're right. If there's no transaction cost to doing it, and we're not going to, and there's no punishment in the criminal justice system anymore, what's the disincentive, right? Criminal deterrence is critical, because if we don't have it, we can't keep the peace. Keeping the peace is what it's all about. At the end of the day, no victim cares if somebody serves, you know, 18 months or 19 months. You know, some of these gradations later don't matter. It's that they got caught, they got punished, they got condemned, and something happened. And that's what people want. And it needs to happen quicker too. If you look at our system, you see this, and you know, this happened to us in Michigan was, now these people are spending years in jail pre-trial when they don't post bail. That's bad. That's bad, because they don't even remember what they did by the time it happens. There is no hitting them deterrence when it happens years later. It doesn't, the criminal justice system doesn't function. And it's even worse when they're out of custody and then, you know, they don't go to trial for 3 years later. Then they go, oh, what difference does it make? I can do it now and I can do it later. And sadly, you know, one of the lawyers in Houston, Texas told me, you know, literally, Jeff, failing to appear is a pretrial legal strategy. If you don't want to get a DUI in Harris County, Texas, you don't have to. You just don't go. You just don't go. And the problem will take care of itself. Once people figure that out, they realize, hey, you know, this system is bogus. I just have to jump through a few hoops and it's going to be fine. And that's not the message that we want to send at all when it comes to criminal deterrence.
One of the other things that this video talked about, there was a specific quote that said, it's completely up to the bonding company to decide whose bail they'll pay. And while the video doesn't explicitly say this outright, they get to that later on, the implication from the visuals in that video is that these are race-based decisions by the bonding company. That, you know, obviously I would reject the notion that we're making decisions based on race, but isn't the ability to be selective as to your particular client one of the strengths of the bail bond system?
Well, yes, because if you know the family and the other bondsman doesn't, and it presents a higher risk, but you're willing to take it because you know the family, then somebody gets their right to bail. So yes, we want this competition in the bail system. You know, this argument that the bail bondsman sets the bail is ridiculous. We've heard it for years. The judges set the bail. Nobody has to use a bonding company anyway. In most states, you can post a property bond. You can post cash. In most states, you can post securities. There's ways around it. You don't have to use a bonding company. What we learned through the movement west of 200 years was that, you know, recently immigrated people to this country didn't have a personal surety. They didn't have somebody that would step in. And that's how the bail bond industry came about. One of the famous lines from the 1800s was, the bail companies are a friend to the friendless. And that's what we really are. We're the ones that step in when nobody else can. And that's why the US Supreme Court said the distinction between a personal and compensated surety has been nearly effaced. It's mundium. It's old law that doesn't really matter anymore. So no, I think that's important. I think competition's important. I think all of this, as I've said, you know, bail agents have an economic incentive to decarcerate the jails. We need to keep that. When there's no economic incentive by a private actor, and it's just based on the government system, there's no incentive. And to keep the right to bail sacred is how you fight policies of detention, is that you have somebody who's able to act as a personal surety, compensated or not, to get the defendant out. So the bail companies, yes, they have an impact because, you know, they're the last line of defense. If you get to, I can't post full cash, I have no personal, and I got to call a bondsman, I'm trying, we are the last line. I understand that if a bondsman doesn't make that decision, somebody stays in jail. But, you know, I don't think we're the ones that are the deciding factor generally at all. Well,
in every sort of pretrial release, there's some level of selectiveness. I mean, if you look at things like even the Arnold Foundation PSA, you know, it has a whole host of problems, but it's still selective as to, you know, what it's recommending as far as release and who gets out. And even the bail project itself, or in other bail funds, they're notoriously selective about who they actually post bond for. I mean, the Minnesota Freedom Fund had what, $25-30 million in donations. I didn't see them step up to post bond for Derek Chauvin. And I didn't see the Bail Project, show up in Wisconsin to post bond for Kyle Rittenhouse. I mean, those are both political cases where people were accused. Obviously, one was convicted and one wasn't, but they weren't selecting to post those bonds because the people that were funding them obviously wouldn't have cared for that.
Yeah, exactly. I mean, everybody says everybody's innocent except the people that we say that aren't. And that's exactly why a system of preventative detention is wrong and why a system of bail is better, because it's based on legal precedent of what excessive bail is, which is old and makes sense and counters politics. It's not, I don't like this guy, so I'm going to seek detention. And that's why was the argument against preventative detention in the 80s, that it would be used as a political tool. And I used to argue, you want Donald Trump to have the power of preventative detention? And everybody would say, no, no, no. And I said, well, he's already got it. So what do you want to say about that? He can pick and choose who he wants. He can go to the Justice Department and say, file a motion for detention. We don't like this guy. And to me, that's just a bridge too far for the presumption of innocence, as we've said, and the right to bail, which is, no, that's not the purpose of what it is. Bail is an exception to detention. That's the filter through which people get out, and judges are the ones making those decisions.
Okay, well, let's touch on the third rail around this issue here, and that's the issue of race. The Pretrial Justice Institute just announced here recently, as they came out from their self-imposed exile, that there is no pretrial justice without racial justice. The TED Talk video states that bail disproportionately hurts people in low-income communities and communities of color. Going so far as to say judges often set higher bail for people of color than for white people accused of the same offenses. And this sort of reminds me of one of President Biden's gaffes when he said that poor kids are just as smart as white kids. It's sort of this, the white savior complex as relates to bail. But is bail, and this is probably a question for you, is bail racist? Does it disproportionately impact people of color? Or more importantly, does it negatively impact people of color more than any other aspect of the criminal justice system?
Well, is it worse than any other aspect? I would say no. I don't think I think the criminal justice system is the criminal justice system. I don't think any part of it is more racist or less racist than the rest of it, if that's the standard. I am familiar with studies that do suggest that, certain oppressed communities have higher bails for the same crime and based on the same criminal history. And I do think that's problematic. I think you wouldn't want to see that. Whatever the measure of risk is, you wouldn't want race to be correlated with that. You would want risk based on risk. Now, the criminal justice system disproportionately affects people of oppressed communities in general. We know that. The reasons for that are too long to get into on this podcast. But what we also know is that victims of violent crime, those most likely to face gun violence, are young African American men in their 20s, who are largely the victims of and the perpetrators of these crimes, unfortunately. And there's a lot of reasons for it. Gang violence primarily is the driving factor of a lot of this that drives it. So I think, the criminal justice system is trying to keep the peace. It doesn't pick the victims. It doesn't pick the criminals. That all happens long before we get here. And so, I don't fundamentally think that the criminal justice system itself drives who comes into it. I think that's driven by socioeconomic factors. And I look at what Oprah is doing. I look at her saying, look, it's a problem of a bad zip code. Your zip code correlates more with bad outcomes in your life than any other factor we could come up with. And why? Bad neighborhoods, kids go to gangs. Simple. We know that. And so to combat that, I think, is a larger social issue, because we still know that we had housing segregation that we still have. And we don't want that. We don't go out and say we need that. But what we also do is don't go out and say, how can we undo that? Because we're too locked in our political mindset that it either is or it isn't. And we can't admit to ourselves that there is still legacy problems from 100, 150, 200 years ago that we need to solve. And the Pretrial Justice Institute, for them to throw up their hands and say there's no pretrial justice if there's no racial justice is to me a complete dereliction of duty. There's plenty they can do to help indigent parties and African American parties and other oppressed communities in the pretrial justice space. There's plenty they can do. And to throw their hands up and say, wow, if there's no ultimate racial justice, whatever that means, and there's no metric for that we can't solve anything, is a complete dereliction. Go get to work, go help make the system more fair, go make it more transparent, and let judges go be judges, and let's educate them on what the issues are.
Well, the Pretrial Justice Institute spent at least 10 years actively promoting, risk assessment algorithms that, until the ACLU came out and decided were, racist assessments, that is this just them trying to recover from the fact that they advocated for what, I guess their side of the issue is calling racist now for over a decade?
Well, I won't speak for them, but what I will speak for is that they advocated not only for the use of a risk assessment, but the risk assessment would replace bail and be the sole deciding factor as to somebody stays in jail under preventative detention or not. So not only did they advocate for the use of the risk assessment, they advocated for preventative detention. So if their world had come into view, people could say that the preventative detention policies that they advocated for have resulted in denying bail to this group of people who are largely a minority. And that's what we've seen, exactly what we've seen in New Jersey, that the mix of people in jail, the racial disparities have increased precisely as a result of these policies, because prosecutors, if they're going to target racial minorities, according to them, in the bail system, they'll target them even worse when it comes to detention time. And that's what we're seeing. So their outcome, and they knew it. And once it blew up in their face, all of a sudden, ooh, it was time to change our message. And we knew all along it was going to blow up in their face. And we knew all along that, if you want to argue the system's racist, well, that's fine, but this is not the solution. And that we knew early, and that certainly blew up in their face.
Well, breaking off small pieces of the criminal justice system, whether it be bail or police or what have you, those are not going to solve the underlying problems that necessarily drive crime.
Of course not. We know that. I mean, it's just stupid that we know that most prevention programs, 12-to-1, 15-to-1 ratio on investment. Criminal justice, what do we get ratio on our investment? 0. We lose money, right? Because we have to put them in prison. We have to do all this. And we have this great mentality in this country that people who are broken, who are drug addicts, who have co-occurring disorders are going to pay for their own prosecution. They're going to pay back the victims. They're going to pay for everything. And they're not. We know it. And we continue to use cash-based programs where offenders are paying for stuff because we think that's going to work. And we say, oh, yeah, of course, that's going to help them get the two things they need to prevent crime, right? Criminogenic factors, housing and employment. Well, yeah, of course. If we take all their money and we don't give them treatment, they're not going to make themselves any better. So, there's a lot of things we can do in the criminal justice system to get better results, but to just throw our hands up and say, oh, we need racial justice is ridiculous. I mean, it's pie in the sky thinking, unfortunately.
Well, you touched on preventive detention, and in places that have adopted bail reform and seen crime explode as a result, there are many discussions. I mean, some have done it already, but there's many discussions about either rolling back the reforms or, as you noted, more ominously, increasing preventative detention rather than simply reverting back to the secured release that a professional surety offers. Tell us about preventive detention, how that works. And doesn't it basically the arguments that were made in this video earlier about the presumption of innocence, doesn't that just take a sledgehammer to those types of arguments in a way that bail never could?
Well, certainly Justice Thurgood Marshall thought so in dissent in U.S. versus Salerno. Little history on that. I mean, in this country, all persons will be bailable by sufficient sureties. That language was in the original Judiciaries Act, the Northwest Ordinance. That language meant that you had to set a bail unless it was a capital case. Or a case punishable by death, which actually was more felonies now than the taste for the death penalty has waned, as we know. But our tradition has been generally that if it's not punishable by death or a capital case, that you get a bail set. That the judge has to go through the analysis. That's been our tradition up until really the 1970s, and then in Shaw, that you could detain juveniles preventatively under certain circumstances, came this notion of preventative detention, that some people are just too dangerous and that we can detain them. That was the beginning of the Washington, D.C. system in the 1970s, engineered in part by former professor the late Daniel Freed, who was a major bail expert. When this issue came before Congress as part of the Bail Reform Act of 1984, which was the idea that we could have preventative detention for a large number of crimes in the federal system, Professor Freed advocated against it, as did the ACLU, and said no. That's contrary to our tradition of this country of the right to bail. The U.S. Court of Appeals for the Second Circuit held the Bail Reform Act unconstitutional in a case U.S. versus Salerno. Two members of the Genovese crime family were preventatively detained, Mr. Vincent Cafaro and Fat Tony Salerno, just too dangerous. And of course, as Judge Amalia Kearse points out, that once Vinny Cafaro pled, all of a sudden he wasn't dangerous at all, and preventative detention quickly wilted away. And so that exposed the idea that this was antithetical to the tradition of this country of punishing people, of defining what the crimes were and punishing people for those crimes. The Supreme Court, in what I believe to be one of the most wrongfully decided decisions that we should take a look at, or realize that it's not as expansive as it was meant to be, was that you could preventatively detain people in certain limited circumstances and with certain procedural safeguards, speedy trial, right to separate detention, and all these other safeguards, right to call witnesses that we imposed. As a result of that, states in the 80s and 90s expanded preventative detention. You look at Missouri's constitution, and there appears to be no limit to whoever we want to detain. And certainly I don't think the Supreme Court would go for that. Have these policies had an impact on reducing crime? I don't think so. There's an article from the 80s that said preventative detention, a constitutional but ineffective means of crime control, and explains why. That it's still a question of deterrence, and that you're not going to detain everybody, and you're still drawing a line of detention eligible and not. Whereas you'd rather just make it based on the defendant's circumstances of this crime and let the judge decide. So there's been no evidence that these systems of preventative detention are superior. What we have seen in the federal system is a growth of preventative detention from, a 24% under bail, when originally they would preventively detain 2% in the federal system that were the capital cases. 22% couldn't post bail of detainees, 76% got out. We flipped that the other way now. So 76%, 75% don't get out, and 25% do. Those that get out don't have to post bond, but they're, of course, supervised by the federal pretrial agency, and then of course the U.S. Marshals can arrest them. So in the states, mixed bag. Some have like a 3 strikes and you're out provision. Some have just no preventative detention, like Colorado for capital cases. So it's been in vogue at times as a solution because, it's not based on wealth. But again, there's just been no evidence that denying the right to bail altogether is a better system, rather than focusing on the core of what bail is about under Stack versus Boyle, guaranteeing appearance of the defendant in court. So I personally am against preventative detention, and we fought against it hard that I've been around for the last 7 years.
Well, I know that the ACLU was one of the groups that filed an amicus brief, in the Salerno case to argue in support of bail, and they seem to have flipped to a certain extent on their philosophy on that topic.
They certainly have, and they testified against the Bail Reform Act for years because it wasn't a one-time shot. I think they had hearings in 81, 82, 83, and 84 before they ultimately passed it. And I think Ira Glazer was their chief legal counsel or their director at the time. I have a copy of his testimony sitting at my desk over there. So they certainly were anti-preventative detention. When I started this job and I started working for the bail agents of Colorado, and I had a saying, if you don't understand preventative detention, you don't understand bail reform. You just don't, because that's the end game of getting rid of bail. It poses the question, if we don't, end cash bail, and then what? And that's been popular on both sides. Let's ban the Department of Education. Well, then what? Let's ban the Department of Energy. Well, then what? Well, let's ban bail. Well, then what? It's going to mean detention. Nobody's going to say, except for people in San Francisco and a few advocates, that we should have no preventative pretrial detention whatsoever. Because if we did, we wouldn't need police. We would have post-conviction police to go pick people up after we convicted them. We wouldn't need any of this. And that's certainly not been our constitutional tradition.
Well, in my last podcast with Gerald Madrid from New Mexico, we talked about the pendulum of pretrial and law, and how laws get formed, and that you swing one direction where you let everybody go like they are in New Mexico, and eventually you're going to get that pendulum swing back the other way. And you've probably seen that happen in New Jersey as well. You referenced that their number of pretrial detainees has gone up in the last half decade than what it was before. So, the people themselves are going to demand that more people get thrown back in jail if they still see crime going out of control.
Yep. And that's why it's an endless cycle. It's crime of the day. That's why we tell legislators, don't crack the door to preventative detention, because once it swings open, it's going to keep swinging. Because you'll always argue, well, there's crime, we should lock more people up. There's crime, we should lock more people up. Rather than let's set appropriate bails as part of an overall deterrence mechanism for crime. And then when they do get out, at least there's security to make sure that we get them back. And that keeps the criminal justice process rolling to where the swiftness and certainty of the punishment, it all happens. So we're greased of the criminal justice machine, the bail process is. And this, again, to pass a bill saying we want to decrease racial disparities in the system, to filing 24% motions to detain in the first year, to filing 47% of motions to detain, and increasing the percentage of African Americans in jail pending trial, it's not a success. And anybody who says it is doesn't know what they're talking about. I mean, and they say, well, a lot more people are not in jail. That's true, because they started using citations on a bunch of cases that they didn't need bail for. But you don't need pretrial detention. You don't need preventative detention to do that. They didn't need to do that. They could have done cite and release policies that any number of sensible jurisdictions have implemented over the last 30 years. If we don't need to arrest people, then let's not. We get that.
One of the cases that's been used like a bludgeon against the bail bond industry is the Khalif Browder case in New York, where Mr. Browder was arrested when young. I don't know if he was quite a juvenile at the time, and placed into Rikers Island with a relatively small bail of $3,000 bond. And that his family didn't post that. And then he spent the next 3 years in custody. The case was ultimately dismissed, largely because the complaining victim had been deported and was no longer available to testify. And then Mr. Browder committed suicide a year or so after he was released from Rikers, and the blame has been shifted to the fact that he wasn't able to post bond during that. However, a little more in depth on that, my understanding is that after the first 30 days, he had a parole hold placed on him and essentially was preventively detained for 2 years and 11 months of that 3-year time. And does that, when that Khalif Browder argument gets brought up, because it continues to get brought up, but isn't that really a better argument against preventive detention than it is against bail?
Absolutely it is. And he was bailable. When this happened, I was involved with the reporters reporting on it, and we pointed this out. And I think he was bailable for a matter of hours before the hold went on. Like for a day or two, he was bailable, and then the hold went on. The family had previously posted his bail, and there was every reason to expect they would this time. So that's a question of, should we have automatic non-bailable holds on cases? It's also a question of who waived speedy trial. Where were the lawyers on this? Why were not you advocating for a speedy trial in a misdemeanor case? Like, why does somebody have to sit there for 2 years? Which illustrates another proposition, which is, why don't we have speedy trials on in custodies? Why don't we have faster trials? Some states do, New York doesn't. But why would a misdemeanor sit there for more than 30 days? Riddle me that. And, data in Michigan, for example, 82% of jail costs caused by 18% of defenders on a pretrial basis. And they stay 30 days and longer. So 82% of jail costs are caused by people staying 30 days or longer. That's how we attack pretrial incarceration. That's how we make the system more fair, is to reduce that time period. So you're right. His case illustrates the fact that had he had the right to bail, none of this would have happened. He would have gotten out, ultimately would have gotten convicted, or case would have been disposed at some point. Maybe he would have been innocent on this charge. That's great. But the point is, he had a non-bailable hold, which is a version of preventative detention. And there's every reason to believe, as in the previous case, that he was on probation for, that the family would have posted his bail. And we have evidence to that effect, that he for sure would have been able to post his bail.
Well, you kind of touched on my next question here, which was, how can these jurisdictions use bail more effectively to both lower jail population while still maintaining appearances and public safety? I mean, you sort of touched on that in the Browder case. One of the ways would be get rid of things like, non-bailable holds for probation violations. Are there other methods they could use?
I think so, but I think it's, just getting back to the purpose of what bail's for. We have jurisdictions across the United States that are using it as a collection mechanism, that we're looking at it as, how much money can we get out of these people? We're looking at it as, can we use 10% of the court so we can keep it? We're looking at cash onlys so that we can keep it. In Colorado, we're doing split bonds to try to persuade the defendant to give us 10% so we can keep it. So we're, getting back to the purpose of it, and Stack versus Boyle, I think is the way to go. And also looking at the idea that all these growth of these non-monetary conditions, even the Arnold Foundation has conceded they're ineffective. They don't work. And so why are we going through this exercise of doing all that? Because guess what? Yeah, the defendant only has a limited amount of money. And if we expect them to pay restitution, well, why are we sucking all their money out of the bank while they're pretrial? Why are we making them jump through all these hoops if we know that this supervision on a pretrial basis is not effective? We know it's not. Why? And they know it's not either, because they're only here for 20 days till they plea, right, on a misdemeanor case. They're being supervised by a pretrial agency. One pretrial agency in Colorado on misdemeanors had them for 21 days. So what type of intervention are you going to have? And they know that because they're moving on to the next guy. So, getting back to the pureness of the bail system and what it's supposed to do, I think would go a long way. And, in terms of guaranteeing appearance, reducing failures to appear, and moving the criminal justice process along.
Just a question I was going to ask before was on the Salerno case. Do you recall off the top of your head what the Supreme Court's vote on that was? Was it a 5-4 or 6-3 type decision, or do you remember?
It was a 7-2 decision.
7-2.
And I think can't remember which justice was. The Chief Justice wrote the majority opinion.
Right. No, it was Drinkwitz that wrote that. I know he was the author of it, because the arguments were that he was the one pushing that, because it just seemed nonsensical that, well, yeah, preventive detention is okay in a non-excessive bail constitutional context. It's like, how is zero bail not excessive?
Well, and you have every advocate on this issue quotes Salerno as a reformer. They say, liberty is the norm, detention the carefully limited exception. But it's like, that's not how it turned out. Detention is the norm, liberty is the carefully defined exception in the federal system. So those words are hollow hope. And people who quote them don't know what they're talking about, but they do. We hear it all the time. On any given day, there's 60 to 70% of people, and we need preventative detention because it would be more fair. And that's really what they're saying. And that is, I don't know, to me, it's sacrilege. But.
Well, it really destroys every other argument. The argument that, people, you're ripping apart, families of color, or low income families by removing the father from the household, by requiring them to post bail. I mean, all of those harms are tenfold with preventive detention over bail, because there's no option whatsoever to get out. You can't do anything to get around that.
Exactly. And they say, well, money bail is coercive on the plea, because if you can't post bail, you're going to stay in jail. But what if you went to a defendant and said, I'm going to move to deny bail altogether? What do you think? What impact do you think that's going to have on the plea?
Absolutely.
Because if people have the right to bail, they at least think in their mind that they're going to be able to get out, even if they're not. There's at least some hope that you're going to be able to get out. You can go to hearing. You can advocate for the judge. Maybe you can call that uncle that you haven't talked to in 10 years. There's some hope that you're going to get out. And so, advocates that advocate for preventative detention, they say, well, bail is de facto preventative detention. They call it de facto preventative detention. Well, bail is de facto preventative detention. I say, well, if that's illegal, if you think that judges are using bail as a back door to get detention, why would you want to turn that into the front door? Why would you want to turn the illegal back door that you despise into a legitimate, open front door for prosecutors and judges? You wouldn't. You would fight against excessive bail. You would fight to lower the bails. You would fight for indigent parties within the existing framework, because you'll get better results. And if you like these bail project people running around bailing people out, you got that going for you too. Guess what they can do under the system of preventative detention they can advocate for? Nothing. Zero. They're out of business. If they disagree with a judge, guess what? You're done. And that's why bail is a check. That's why bail is a check upon the government. The populace can say, not this time, buddy. And under systems of preventative detention, they can say, too bad. And to me, that's just antithetical. Everybody should go read Judge Kearse's opinion declaring the Bail Reform Act unconstitutional, and go read Justice Thurgood Marshall's dissent. And I put this out a million times. Go read that, call me and say you agree with preventative detention, because nobody ever has. Nobody ever has in 7 years.
Yeah, if you argue for preventive detention, you just can't make the other arguments that you're making anti-bail, because it's only worse with that.
Exactly.
Now, you touched on the Bail Project, and I've referred to their video multiple times throughout the course of this. And there's some legislation and an ongoing lawsuit involving the Bail Project in Indiana. Can you tell us about that? I mean, what's going on with that lawsuit? What's the general idea of that legislation there?
Yeah, so several states have introduced legislation, and then several have passed it, limiting what charitable bail organizations can do, making sure that they're licensed, and just imposing basic, kind of requirements that are on the rest of the insurance industry, including bail agents. that if you engage in immoral or unethical or outrageous illegal conduct, that we can pull your license, that there's some oversight and accountability of what they did. So that's kind of what Indiana did. They limited some of the crimes, violent crimes that they can't post bail in. And so they had a basic regulatory framework that the Department of Insurance would oversee and require them to get a license. The Bail Project filed a pre-enforcement challenge in federal court, arguing that this made me laugh, that posting bail is a First Amendment right, that it's core speech, and that the department couldn't regulate. Federal judge looked at it and denied their request for a preliminary injunction, meaning that the law went into effect. I don't think they have much of a credible argument that they shouldn't be regulated. I mean, I think the legislature can always put qualifications on what sufficient sureties is. There's some reason to believe that, because the money's crowdsourced, that they don't qualify as bail by sufficient sureties as a matter of law, because the money's too remote and all the incentives have broken down. And so it's like giving somebody a get out of jail free card, in a sense, because there's no incentives, there's no personal surety, there's nobody that's going to do anything, and it's not their money. When the bail agent of the Bail Project goes and signs the bond, well, they're not guaranteeing anything because the money's not theirs. It wasn't theirs in the first place. So, I think there's probably a need for some baseline regulation of these. We've certainly said it's fair if they're going to do it on a charitable basis. And I think, to have the Minneapolis Freedom Fund going around saying they just randomly pull a file and they don't actually screen people they bail out is probably problematic. I think there's some negligence there. They should at least look at the people. They should at least look at the criminal history. They should at least look at whether they have friends or family and why they don't before they post a bond. I mean, to me, that's just basic negligence. I think any bail agent would do that, would at least look and say, who am I dealing with here? What have they done before? Have they showed up? This sort of thing, to take some baseline evaluation of what they do. But I think that'll be fought out in court. I think, the victims of these crimes will ultimately sue the Bail Project and sort out, what negligence they engaged in on some of these when they just posted out people that, that maybe a rational person in the bail industry probably wouldn't have posted on.
What was I forget it was some strange term as far as, advocacy that they were engaged in, that they were using that term to get it under the First Amendment issue. And I can't remember if you recall what that was or not. It just was something that I'd never heard before. Yeah, I have
to read the decision again. It's not coming to me at this moment, but basically that their core political activity of what they were doing was core speech.
Right. Functional advocacy or something along those lines.
That's really not the case. They're engaging in an act. We know what advocating for bail reform looks like, and they're doing that on one hand, but they're also posting bails, which is a specific act that's not protected from regulation. And Indiana regulate that anyway because they have a close familial connection required to post a bail. They don't allow strangers to post bail in Indiana, so they couldn't make that argument there.
I assume other than bondsmen. Someone who's actually regulated by the insurance department or the local courts.
Exactly.
Okay, well, let's kind of summarize this and kind of wrap this up so we can get back to work. Some of the main anti-bail arguments there argue that the presumption of innocence means that you can't, require bail, that people sit in jail based solely because they lack funds, that bail has to be affordable, that there is no increased crime from bail reform, and that bonding companies are unfairly selective, and that bail is racist, and that preventive detention is a better argument. And I think you've done a great job of showing how, or at least I guess in the current vernacular, of debunking all of those claims. So thank you very much for your time today, Jeff. I think you've done a great job of looking at these in a very analytical way.
Well, thank you. It was a pleasure to be on.
Thank you for joining us today on the Bail in the Midwest podcast.